Yes, sir.
Yeah, Tushar, we can start the program.
Okay, sir. Good
Yeah.
evening to one and all present here. On behalf of the Moot Court Committee, Hilsa, School of Law, Jamia Hamdard, I welcome you all to the inauguration ceremony of the first Intra Moot Court competition. The competition shall take place over a period of 4 days, that is, from 1st to 4th Feb. Without any delay, I request Professor Dr. Salina Bashir, Dean School of Law, to give the welcome address.
Thank you, Sakshi. Honorable Chancellor, Janab Ahmed sir, Honorable Vice Chancellor, Professor M. Afshar Alam sir, Professor Iqbal Hussain, Dean Jamia Millia Islamia, Advocate Bhagat Chuk, Faculty Convener Burhan Majid, faculties of Hill sir, members of Moot Court Committee, my dear students, all the participants. It's a moment of great pride and honor for Hill sir. It's going to be a historic occasion for Hill sir, a moment of jubilance and glory. So I wish let this Moot Court be an academic stimulation of appellate advocacy to my students. Let it educate my students about law and judicial process. Let it improve my students' critical and analytical skills. Let it be a new, exciting, unforgettable experience for my students. Let it teach you to act professionally and ethically. Let the Moot Court enhances all the important skills that the law school offer the students. Let it teach you to think like lawyers. Let it prepare you for a competitive world. Let my student competitors will be a better lawyer and a better person. So on this occasion, it's my privilege and great pleasure to welcome you all. I welcome our Honorable Vice Chancellor, Afshar Alam sir. Sir, it's through your relentless encouragement and support we are here. On behalf of Jamia Hamdard, I wholeheartedly welcome Professor Iqbal Hussain sir, Dean Jamia Millia Islamia, for inaugurating our Moot Court. Sir, we are really thankful to you for gracing this occasion, your continuous engagement and guidance for us. We are grateful to Advocate Bhagat for accepting our invitation and becoming a chief guest for today's program. It will be great to hear from you as a keynote speaker. On behalf of Jamia Hamdard, I welcome Advocate Bhagat Chuk. Dear Burhan, it's your sheer wisdom, patience, and meticulous hard work. We look forward for more virtual Moot Court competition and also physical ones in the near future. So there may be only one team that can win the situation, but I wish all the best success for the participants, and I believe that the organizers and the participants will enjoy the event. It will be a real success. Thank you.
Thank you so much, ma'am, for the wonderful words. Now I request Professor Dr. M. Afshar Alam, Honorable Vice Chancellor, Jamia Hamdard, to please deliver the presidential address.
Thank you. I am delighted to be the part of this Intra Moot Court competition inauguration ceremony organized by our Hilsar Law School today. I am glad to see that Hilsar is gaining momentum by day in terms of the different program and competition it has been able to organize in the recent past. In the present time, as you all know, the law schools around the world are expected to deliver beyond the classroom, like training students to improve the courtroom skills and, of course, prepare them to be the social engineers of the day. This is because of the job of the lawyer has never been to be merely the mouthpiece of her client, but to contribute in the overall administration of justice in a given society. I believe Hilsar is doing quite well to live up to these expectations. The law school is particularly doing its best to organize a moot court competition, both at the university and national level. I am very happy that it has recently announced its first Hakim Abdul Hamid National Moot Court Competition 2022. This is indeed a proud moment for all of us at Jamia Hamdard to have a national moot court competition named after the founder of the university, Janab Hakim Abdul Hamid Sahib. You would be already aware of the eminence contribution of Hakim Sahib has made his turn of setting up a university and upliftment of weaker and backwards section of the society. So this is perfectly goes well with our intent to produce a generation of social engineers at a time when they are mostly needed. The mooting is the only activity that comes closest to being a lawyer while still studying at a law school. I would urge all the students of Hilsa to participate in moot competitions, as a moot offer you a lot more in terms of training, use research skill, legal drafting, ultimately do oral advocacy skills. Mooting not only challenge the student to think on their feet, but also formalize them with a different kind of court craft. This is also contribute toward their holistic development as a legal professional. In this process, students begin to build and enhance their legal equipment as they undertook research and analyze the question of law. It's quite interesting that the moot proposition for this competition is based on very contemporary question of law, like the legality of a mandatory vaccination and lockdown. This is how we in academia bridge the gap between the theory and real world life. I hope the Hinsar is able to make its regular ritual in future to hold at least one intra and one national moot court competition every year. The law school should be actively organize workshop to train the students in mooting as it done in the recent past, so that they are able to participate in the competition organized by other law school and perform with flying color. I particularly glad that Professor Iqbal Hasnan, Dean Faculty of Law, Jamia Millia Islamia, and Advocate Bharat Chub have taken their time from this busy schedule to spend time with our students to inspire them. I wish you all the best for this competition ahead. Thank you very much.
Thank you so much, sir, for enlightening us with your words. We have with us today Professor Dr. Iqbal Hussain as our chief guest for this ceremony. Professor Hussain is serving as the Dean, Faculty of Law, Jamia Millia Islamia. So I request sir to kindly address the gathering. Sir, I think you are on mute.
Am I audible?
Yes,
Yes.
sir, you are.
Honorable Vice Chancellor Jamia Hamdard, Professor Dr. M. Afshar Alam, the Dean Faculty of Law of School, Professor Dr. Salina K. Bashir, Advocate Bharat Chuk, the former judge and an alumnus of Jamia Millia Law Faculty, Madam Nazish Fatima, Assistant Professor of Law, Hilsar. Let me first of all congratulate all of you for organizing the first moot court competition in Hamdard Institute of Legal Studies and Research. Indeed, it is my honor and privilege to be invited as a chief guest for such a historic occasion that your law faculty begins today. Coming to the moot court, indeed, this moot court competition and the moot court training as a curriculum in the legal education in India that came recently, not very recently, but when the complete overhauling of the legal education took place almost 2.5 decades ago. And the 5 years course was introduced, and resulting thereby, today we have almost 28 national law universities in the country. And almost all the traditional law faculty have adopted these 5 years integrated legal education in this country. In fact, in the Legal Education Rules 2008 of Bar Council of India, Part 2nd B. This is the compulsory clinical course. There are 4 clinical courses which was added, which is one of the necessary component for the legal education in India. The first one is the drafting, pleading, and conveyance. The second was the professional ethic and professional accounting system. The third one was alternative dispute resolution. And the fourth one was the moot court exercise and internship. So, moot court is not only a kind of internship or training, rather, it is a compulsory course legal under the legal curriculum incorporated by Bar Council of India. The moot court is a part of clinical course, and this clinical term has been adopted by the same meaning as it is in the medical sciences or the medical education. So the theory part of the medical teaching that is done in the classroom, and this is the practical part that the students has to visit the hospital to see the practical part, that how this medical teaching is being exercised and practiced over the patient. Without this, the teaching is not complete because it is not theoretical. The ultimately the the recipients of the degree of both medical as well as the legal, they have to go for the practical exercise because the law is exercised in the court of law. Therefore, this concept was adopted from the foreign legal education, and today it is one of the most important component of our syllabus. Now coming to the moot court, in every college, as I mentioned, this has become one of the compulsory exercise. And not only this is being encouraged by all corners of the legal field, whether it is the legal firm, whether it is legal offices like corporate sectors or Bar Council of India itself. They are organizing very religiously every year the moot courts, and as well as all the law colleges and the law universities. So now it has become one of the most important part of your syllabus. Coming to the present moot court competition, my dear young students, it is very important part in your legal education. While much stress is led by educationists on literacy and numeracy, but we hear little about the importance of being articulate. Why is it supposed that the speaking comes naturally and need no effort or concentration? Fluency and clear enunciation are particularly important for the lawyer. Taking part in moots will help you in these respect and also give you experience in the part of persuasion and of putting a case succinctly and intelligibly. Moot court competition such as this seeks to familiarize you with the important branches of law and complex concepts involved in it. Learning it through participation in a moot court makes it more interesting, as well as the work is carried out with team spirit. Moot court competition provides an excellent opportunity for young students to learn legal skills. It trains them in the art of advocacy, which we know is not easy. One has to do meticulous research in preparing a case, and then, while presenting it before judges, she or he has to be articulate enough to convince the judges of the merits of the case. An advocate has to be well versed in the procedural as well as substantive law. Above all, an advocate has to always remember that his work is in the cause of justice, which she or he, as an officer of the court, is duty bound to realize and protect. These are the some of the qualities which I feel are required in an advocate, and it comes with sincerity of the purpose and devotion to the profession. I think these are the few tips that is the significance that entails, reflects the significance of the moot court. I think I should not take much of your time because the keynote speaker, my former student and a great advocate, young advocate of this country, Bharat Chok, who has been, who has topped in Delhi judiciary after acquiring his degree from Faculty of Law, Jamia Millia Islamia. But after some time, he realized that he feels bounded by his liberty, and he jumped over to the litigation. He is the best person to tell you practically from the horse's mouth that what is the significance and what are the suggestions, how the new budding lawyer will initiate and enter into the court, and what are the significance of the moot court. With this, I once again very thankful to the organizers of this first moot court competition, and I am very thankful to the Vice Chancellor for his benign presence and inviting me to his institution. With this, I wish you all the best. Thank you very much.
Thank you so much, sir, for gracing the occasion and enlightening us. We also have with us today Advocate Bharat Chugh as a keynote speaker for the event. Advocate Bharat Chugh completed his BA LLB honors from Jamia Millia Islamia. In 2013, he secured the first rank in Delhi Judicial Services examination and was appointed as the youngest civil judge of his batch. In 2016, he resigned from judgeship and joined L&L Partners. In 2019-20, he became a partner at the firm. At present, Advocate Chugh is an independent practitioner and the founder of the Chambers of Bharat Chugh. I request sir to please deliver the keynote address.
Thank you, Tushar, for that introduction, and thank you, Professor. It was your unconditional love for me that was speaking there. I'm hardly worthy of it. I'll just make one correction. Sir said former student. I'd say a student, student in the past, in the future, always, and really look up to Sir. So it's an absolute honor to be sharing the space with him. And thank you, Jamia, for having me. I've had the occasion of speaking with many of you on the art of advocacy, I think a couple of months back. I don't know how many of you were there in that discussion. I would hate to repeat. If you could just have a show of hands, or if you could just put it in the chat box, if you were there in that discussion that we had, that would really help me talk either differently or touch upon some of the areas that I haven't touched upon in the past, and make this more efficient in that sense for your time. So I can see some hands of a few people who were there. Okay, a few more. Perfect. Because I remember we had a very long discussion on what are the things that go on to make an effective lawyer. How do you build court craft? How do you prepare for matters? How do you uh, study a case? How do you make notes? How do you get out of a difficult situation in the court? How do you use wit to somehow get out of a sticky situation? How do you respond to a question that's tough and that you don't know an answer to? Okay, a lot of hands then. So clearly, I should be careful not to repeat the things that I've already spoken about. Thank you very much for your kindness. Thanks. Before I start, and I only have a few minutes, I understand. And at the very outset, many congratulations for doing this. I cannot emphasize the importance of these intra-faculty or intra-college moot courts enough. Sometimes, I think they're the right stepping stone, especially for people who are starting out with mooting at the very early stages. I think it's the right start. Sometimes, for instance, one of my first moot courts was an international moot court competition with teams from across the world. And at some level, I mean, I had qualified certainly with my written memorials, and but when it came to the oral arguments in that competition, at some point I felt that I could have had more experience playing domestically, playing within my faculty, or playing with my peers and testing my strengths and weaknesses and learning more. uh, so these competitions like these have a very important role to play in preparing you, in testing you out. So congratulations for doing this. I personally always tell, whenever I speak to students, that doing a moot court is like being in a bouncy. You can jump, you can stunt, you can do all that you want, and even if you fall, you don't get hurt. So there is no client who would be sent to the gallows if you make a problematic argument. Nobody's going to lose their property or their life or their personal liberty. uh, so it's an extraordinary opportunity, and let me tell you, you would not get these opportunities after you are out of law school, because even on your day one as a lawyer, I mean, some judges may show you some indulgence, seeing it's a young advocate, and give you opportunity or let some of your mistakes pass. But broadly, you are out there on your own after you graduate, and every argument that you make, everything that you do in a court of law is going to have real life implications on the lives of people, right? And also for your own career. So moot as much as you can during the law school days. It is the closest that you get to a courtroom experience, and it's and sometimes it's even more difficult than a courtroom experience, in the sense that some of the judges would come having read the files really well, and they would sometimes consciously grill you or ask you more questions, because they want to test you and they have to assess you. In a real life courtroom, sometimes the judge may not have the requisite time for a single case where he can spend time with you, engaging with you, asking more questions, trying to dig deeper. But in a moot court, you have the indulgence, or you have the luxury of interacting with judges, answering their questions, and elevating the discourse, and coming out having learned a lot of things. So please participate in them as much as you can. I wish sometimes there would be a mooting competition for practicing lawyers, where from time to time we can go back to the drawing board and try and improve our skills without real world implications on the cases that we work on. So that's on the importance of what you're doing. All the very best for this. A couple of things that go on to make a great mooter is the same as what goes on to make a good advocate. First of all is your mastery over the brief. When I used to moot, I would take it so seriously that it would become an obsession of sorts for me, the moot problem. I'd live the mood problem. At least I'll try to. I would know the characters inside out. I would know what they're coming from, so I wouldn't normally need to go back to uh, fact page number 8 or 9 because the judges have put a question to me. The mood problem was a part of me. I had breathed it, I've lived it. And the first thing that you need to do is have an extraordinary mastery over the facts. See, you can get away with not knowing a nuanced legal question, but you cannot get away in not knowing the facts, because those are there for you in your moot problem. And law, you would of course learn, and the judges understand that. But facts are sacrosanct. Facts are important. You should master them. You should try and tell a good story when you are talking about facts. And don't try reading from papers. I've I must have judged dozens of moot courts so far. It just doesn't develop that connect with the judge who's a human being. Mooting or advocacy is about communication. It's about looking into the eyes of the other person. It's about looking at the demeanor of the judge. Is the judge bored? Is the judge leaning forward? Is the judge leaning backwards? Is the judge smiling on certain aspects, nodding on certain issues, but there is a scowl or a frown on the judge's face when you make a particular point? You have to be very, very sensitive to those cues. It's nothing but emotional intelligence, like having a conversation with anyone else outside the courts. In a lot of ways, it's like that. You need to see if the person is receptive. You need to make it interesting. When we are arguing sometimes, there was this arbitration that I was working on, and a very intelligent arbitrator, by the way, a retired judge, very, very learned. um, uh, but for some reason, he had the tendency, unfortunately, to sometimes doze off during the course of arguments. Now, what do? You're making a very important point. Millions would be turning on that point when you're orally arguing the case at the end. But you see that, and it's not because the judge is uninterested. Sometimes because of age, because of a number of issues, the gentleman is tired. But at the same time, you also have to ensure that there is nothing lost in communication, right? You are trying to make a point, it should be received at the end. So what do? You would sometimes, when you're pointing out a page number, you would very, very nicely say, if I could take my lords to page number 79. Do I have my lords on page 79? May I read from here? You've asked a question, right? And in this process, you've ensured that the judge is answering back, oh yes, I'm on 79. What do you have to say? Then in the course of the arguments, you would, if you're going on in a monotone where you're just talking about the case, sometimes you try to make it interesting and say, let me just put that aside for a moment. Let me put a question to myself. Does it even work? So when you said, let me put a question to myself, the judge says, oh, something new has come up, right? You've broken the monotony. So those cues are very, very important. Sometimes, you'd want to say that, okay, these are the facts of the case, but on the lighter side. But this is on the lighter side. Let me come back to the case. You are engaging. The best mooting is when the judges are engaging with you. They're asking questions, or you sometimes ask a question to them. Obviously, they're not obligated to answer your questions. You are there to answer their questions. But at the same time, develop that connect, like you'd develop a connect with any human being. So be very, very cautious of that. Don't stick to scripts. Scripts don't work out well. Even today, I see many, many lawyers who, even in court, would sometimes start off their arguments by saying, may it please the honorable court, I appear for so and so and so and so and so and so. And, with a lot of pomp and show, and they have their script. So the judge may want to come straight to the point. The judge may want to know what is at page number 29 and how do you answer that. So scripts normally don't work out, right? If the judge has read the file. So be ready to know what your issues in this case are. What's the evidence? What are your killer 5 arguments which you have to make, and you have to make them well. Just keep that very, very clear in mind. You should know that the case is going to turn on these 5 arguments. And normally there would not be more than 4 or 5 issues in even the most complicated of cases. But you would have to have the judgment to understand that the case turns on these. These are the important ones, and I'll make them. Whether it's a question of interpretation, it's a question of analogy, it's a question of analysis, whatever it is, you should be clear with those. Don't stick to a script, is what I'm saying. And never ever read from a paper. Have your broad points on a paper so that you don't forget, like your bullet points, that I have to make this argument. This argument has 3 sub-arguments. Be clear with that. If you have to place reliance on a case law, rely on a provision, but at the same time, because you'd be preparing in your own way, you would want to go in a certain fashion, but that's not how a court works out. The court may not want to stick to your plan. As somebody said that the most well laid out schemes of mice and men often go awry. Your plans won't work out. Please understand. So you would have the judge asking you a question and completely derailing what you've thought. Some ways of answering that is that my co-counsel would be dealing with that question. Now that's the easiest, right? Obviously, you'd have a big fight with your co-counsel later, and the cause fissures in your friendship. But that's one way, and I'm not saying that that's a bad way. Sometimes you may say that that is, with the greatest respect, I'm grateful for the question. Thank you for that question. My co-counsel would be dealing with an issue which is similar to this, or would be dealing. That's completely okay. But if you can answer that in one line, that we are mindful of what is troubling you. That is also something that is troubling us as lawyers, and we examined that issue. Let me assure you, we'll answer that. But in one line, let me say, this is the response to your question. We'll elaborate on it when my co-counsel comes up, or we'll take it up. So the judge knows that you've not evaded the question totally. See, even if you have a co-counsel, you are expected to know the case yourself, right? It's not that these are watertight compartments that your co-counsel would deal with two, and you would deal with two questions, and you have no connection with each other. No, you're a team at the end of the day, right? So you should broadly know also what your co-counsel's case is, and that is the only way you will be able to respond. And different ways. I think the best way for one to prepare facts and arguments and law is to talk about it, is to discuss with as many people as you can. Obviously, constructive people that you can have a conversation with. Talk to them about law. Law is all about discussions. Law is all about thrashing it out. You'd say something, the opposite side would call you out. No, that's not logical. Or I don't like the way you are putting it. This is offensive. Or this is not clear enough. You're not communicating. Then you'll get some positive feedback. You'll try to state it differently. But it's, the best lawyers in the business don't read from their files at all. They come to the court, their files closed. They know what is where on which page number. A good memory is something that you need to cultivate sooner or later. The profession is about reading. The profession is about retention. The profession is about memory. We sometimes think that we can't retain a lot, and that's okay. We don't do rote learning. I can understand a concept, but I can't seem to remember. No, remembering is important. There are absolutely no excuses for not cultivating a good memory. The best people in the business can still tell you. See, I was in a conference with Mr. Chidambaram for a matter that I was briefing him on. And we had prepared well and so on. But during the conference, the question came up, and I'm just illustrating it, that every decision has to be, every judgment or every order has to disclose the reasons it is based on. Reasons are important for natural justice, right? Reasons tell you how the judge came to the conclusion that the judge did. It is fairness to both the parties that they should know the decision-making process. So reasons are important. Any order that is bereft of reasons is unconstitutional, illegal, and so on. But Mr. Chidambaram could tell you that AIR, Bharat pull out AIR 1980 SC 454. And we open the book, and there is a decision, a landmark decision of the Supreme Court saying exactly what he did. And sometimes he would know on a given page, is it on the top? Is it on the middle? Is it on the bottom? And it's not that, it can't be cultivated and you're only born with memory. No, absolutely not. By internalization, by thinking about it, by trying to recall it again and again, you can actually learn these things. And it is important for you to cultivate a memory, and you should be able to argue your moots without having to open a paper. Of course, if the judge would ask you, read from this page, or it is a nuanced issue, then of course you make them read from a paper. But other than that, it should become a part of you, and it should not look like rehearsed. Right? So keep these things in mind, and basic niceties. For instance, if you don't know the answer to a question, it's okay to sometimes be humble enough to say that sometimes you can, when you don't know an answer totally, don't just hazard a guess. Concede. Confession. Honesty is extremely important. Integrity is important. If you don't know something, feel free to say that I'm so sorry, but this is not something that we've looked at, but that's a great question. We'll get back to you on that. I'll definitely revisit it. But if I may hazard a guess, if I may try to attempt the question, I've not read this, but if I may try, just caveat your answer with that. Because if you don't say this, that I don't know it, and if I may try, If you don't say any of this, then it looks like you think you know, but you don't know. And that's usually, a very uncomfortable position to be in. So be very, very honest. If you don't know anything, concede. Also choose your arguments very well, not just in mooting, but in court. If you have 4 points, make those 4 points really well. It is not a quantitative test. You're not going to win a moot court just because you argued 15 points and your opponent argued 7. It's not a quantitative test. Arguments have to be weighed and not counted. मतलब arguments का वजन होता है, गिनती नहीं. अब एक argument में भी आप जीत सकते हैं, 3 में भी जीत सकते हैं. तो just be mindful of good points, because every bad point you make, you are losing the judge. Every bad point. So you're totally wrong on law, you're wrong on facts, but you're still making the point because you want to make that point. No, it doesn't work like that. And please test your arguments with your seniors, with people who are more learned than you, because we remain students of law all our lives. Every day we are humbled by the extents of our own ignorance. And if you are every day humbled by what you don't know, then that's the right attitude. The more you know, the more you should know that you know absolutely nothing. And if you cultivate that sort of a mindset, then you will be open to learning more things. And then certainty at that point in life is a bit problematic. So today at 32, I'm far less certain of things and what I know of life than I used to be when I was 22. As you realize that there's so much more to things, there's so much more to law, there's so much more to life. Sorry to be putting too philosophical a point here, but let go of your certainties. In our passion, in our enthusiasm, in our flamboyance, when we've read something and we are young and we have that energy, we think that this is all, but there is so much more. Just keep an open mind, be flexible, be open to learning. And this reaching out to your seniors, this reaching out to a practicing lawyer, this reaching out to somebody, a professor, somebody who's more learned than you, is a very important skill that you would find very useful in the profession too. Today, for instance, I do a lot of arbitration work or commercial disputes or white collar crime, but I don't know a lot about taxation. So if I get a taxation matter today, I talk to at least 3 taxation lawyers that I know who do just taxation. I'm not going to, just claim that I can learn something overnight. They have a lifetime of experience. Why not stand on the shoulders of giants and rely on borrowed wisdom if this is better than your wisdom? Of course, whatever I get from them, whatever you get from your seniors, test it. Never take anything with a willing suspension of disbelief. Never take anything just because somebody's told you that's right. You have to question it, but let your mind be open. Let, as Gandhi said, let the doors and the windows of your house be open to foreign airs and to the streams of different thoughts, but you refuse to be blown away by them. You stand solid. You're okay taking different views. You're flexible. You want to learn. I think that's the lesson, not just for mooting, but for life, in the limited life that I've seen. And and nobody's a born genius. Nobody, in law at least, it doesn't work like that. The myth of genius is something that we need to break. There's law at least is all about persistence and hard work and commitment and focus. You may be very, very talented when you're born, but in law, at least you wouldn't, unless you do hard work, because law is about knowing a lot, spending time with it, spending time with your books. Now, this is possibly would make me very unpopular, but today I feel that, when I talk to younger people or see younger people, the only way you can make them read anything is to make an Instagram story out of it. It's very difficult to get people to learn and pay attention unless you are also packaging in an accessible fashion. See, I'm all for making things easy and making law interesting. I used to write a column back in the day called Judgments Without Tears. It's a complicated judgment. We'll give it to you without you having to cry in understanding it. I'm all for accessibility, but the problem is these days we don't have focus. We are these weapons of mass distraction, as I like to call them, have taken away our ability to be on a document read it again, close our eyes, think about it, take a walk, think about the issue, and do it for 50 minutes at a stretch. Then stand up, walk about a bit, then do it again 50 minutes at a stretch. That ability seems to be going away from us. And I'm equally a victim of this. But spending time with books is important. Walking down the corridors of libraries is important. Sometimes walking down a library physically is has led me to some of the most brilliant books and things that I've read, just because I saw the name on a bookshelf and then I said, oh, let me pick this up. You pull the book out, from a shelf, and then you take up another one which you find in a footnote in that book, and then you go down a rabbit hole, and then another, and then another. And sometimes these tangential journeys that you take, these detours that you take, sometimes give you what your destination is, or at least add so much to you and yourself in that sense. So read, be open, and I think that's that. I'll just stop boring you any further on this. All the very best for this moot court, and uh, just be at it. Being here gives me immense hope, and I hope you'll put your best foot forward. Happy to take any questions. Goes without saying.
If there are any questions, the participants can either raise their hands or put it in the chat box. We'll take each question one by one.
I just promised I wouldn't speak much, but then I ended up, I think, speaking for how long? Yeah, that's the, lawyers, even when we say it's a brief, it's like 1,000-page long. So, yeah.
Good evening, sir. Sorry, I have a question.
Mm-hmm.
Am I audible?
Yes, you are. Please go ahead.
Yeah. Yeah, sir. Actually, I wanted to, like have a brief, this thing, like we have a long judgments in law. How do we have to give it a read? Sometimes it gets too complicated and too boring to understand, and sometimes the language is so difficult that we cannot understand it. So how can we make it easy and make it, like understandable?
See, all things are difficult before they are easy, right? At some point, I think walking on two was difficult for us, but then it became easy. Learning a new skill is always difficult, right? And law and judgments and statute is obviously a technical subject and sometimes difficult to uh, understand. But you'll realize over the years, the more you do it, the easier it becomes for you. Speed reading, for instance, would become easy for you as you go along. If you've read 1,000 judgments and then 2,000 judgments, 5,000 judgments in your career, you'd understand that there are commonalities. You would understand that there are ways of speed reading. There are ways of identifying that this para must be dealing with this issue, and then you see, when we are young, we read alphabet by alphabet. We grow up, we read word by word. Then you grow up and then you can read sentence by sentence. You look at a sentence, it makes sense for you without having to read every alphabet and every word. It sounds very Sherlock Holmes that you look at a page and then it suddenly makes sense to you. But that's how it would become once you master speed reading. You would be able to absorb a lot of information very, very quickly. On trying to make sense, of course, an interpretation of a statute or understanding the meaning and intent or import of a law or a judgment is something that would come with practice. It also comes with a lot of thought. Sometimes we read a lot, but reading a lot is not wisdom, right? uh, Reading some, then taking a step back, and then closing your eyes and thinking about it, seeing how a law plays out in a real world situation. Why was this enacted? What is the purpose sought to be achieved? What are the problems with this law? Is it fair and reasonable? Is it constitutional? Who made this law? Why? Is Can this law be misused? What is the purpose of this law? You'll have to ask all of these questions to yourself once you are reading law, because law doesn't operate in a vacuum, right? It's about you and me. It's about lives. And once you've connected your dry law to a life, it is not dry anymore. It's interesting. It's real. It's dramatic. It's vivid. It's beautiful in that sense to you. So read that law in that fashion and have fun doing it. Today also, that's the kind of culture that at least I try to give to my younger colleagues, that each time a new problem comes, it should excite you. It should keep you up. It should, that childlike curiosity that there is a new problem, that I've got a new toy to play with. uh, and that's so if you've seen a child play with a new toy, the child plays with such sincerity. So if you can master that sincerity of a child at play while you're reading law, I think that's a good way of mastering law and trying to understand difficult concepts. I'm so sorry if I just meandered and didn't answer your question in the process.
Sir, I have a question.
Mm-hmm.
Sir, in practical life, whatever we do in moot courts or whatever procedure we follow in moot, so what are the exact things we apply in practical life, and how is it different from a courtroom?
If you could just clarify for me, is your
Yes, sir.
question? Yeah.
Whatever procedure we follow in moot court, so does it exactly copy paste whatever we do in a practical courtroom? Whatever we say or whatever our arguments are, is it exactly whatever we practice in moot courts, or is it different?
So the core similarity is that in either case, you are trying to convince a judge, persuade a judge to agree with your understanding of the law, your understanding of the facts, and to decide in your favor. That's common between both. What's uncommon is that a real courtroom would have far too many variables. If you have a moot court, for instance, you prepared for it, you know that the judge is going to hear you for 15 minutes. That's the time allotted to you. You know broadly what the opposite party is going to say. You would know what the issues are. In a real court situation, there would be a lot of surprises also for you. What if the judge is on leave, the opposite party is on leave? You thought that the opposite party was respondent number one, but a new person came and filed an application that I also want to be a part of this litigation. uh, the judge threw a question which was totally unrelated. There are too many things that happen in a real, for example, if you're cross-examining in a criminal case, you have no clue what the witness is going to come and say, but you will have to cross-examine the witness. You will have to try and get the truth out from that witness. So you obviously, in a moot court, it's easier that way, because you much of it can be expected. But in the real world, it's slightly different. Of course, in real world, also in courts, you'll arguing before a trial court may be slightly different from arguing before an appellate court. Uh, there would be limitations. For instance, if you go to the Supreme Court, normally you will be arguing only on a question of law. You would not be arguing on facts at all. On appreciation of evidence, you won't be arguing. You'd be arguing either the question of whether the law has been correctly applied, or is a law constitutional or unconstitutional. So different courts, different objectives, different ways of advocacy, but the core in all of these remains the same. In a court of law also, you're communicating, right? In here also, you're trying to communicate. As I said earlier, and this is how I began, that in a court of law, the judge would have 150 matters or 100 matters on his or her board. But in a moot court, you have a captive judge who has to listen to you for 15 minutes as per the procedure. So that's extraordinary opportunity that you may never get in a court, or may not get in the court for a very long time. So there are similarities and dissimilarities. I hope I was close to answering what you meant to ask.
Sir, I have a question.
Mhm.
Sir, your speech was really great. Even though it was long, it was not boring at all. It was really good, and you didn't repeat anything. And I like the wordplay, the weapon of mass destruction, distraction. Your joke.
This is all
Anyway,
all borrowed wisdom. But thank you very much. Yeah.
yes, and my question was, like, everything is expected in moot court. We see everything coming. So how will we win? Almost everything look alike. how do we succeed in it?
That's the whole point, actually. Um, if it's a straightforward legal question, mostly parties would identify the precedent correctly. If there are 5 articles in the constitution that you rely on, everyone would know those 5 articles, everyone would know those 5 standard case laws, right? So there, of course, what sets you apart is your what differentiates you is, of course, your delivery. But delivery is not all. I've always believed that it's content and presentation. You cannot say one is more important over the other. Of course, your legal research has to be top notch. Let me put it this way: if you have to excel and really stand out in a pool of mooters, what are the things that you can do? You have to take it to the next level. So we've tried doing this in our cases where you come up with a foreign precedent. Judges sometimes would be extremely inclined to know what other jurisdictions are doing with it. Sometimes, we are content with dealing with how law operates in the country, but when you are able to pique the curiosity of the judge and say, I'm also relying on a judgment of the US Supreme Court, which I understand may not be binding upon the honorable court, but is still persuasive, or may throw some light on the issue because they have suffered from the same problem. This is how they dealt with it. Let's see how they dealt with it. That adds to wit. Humor adds to clever wordplay, as I said. Quick turn of phrase, something fun that you say adds to makes the environment more pleasant, makes them like you more. Of course, wit or humor is not something that you can script, right? I mean, it takes time to be, and you can be funny when you're confident. See, if you're not confident, then there's absolutely no point being funny. I mean, that would be the worst stand-up in the world because you have to be comfortable in your skin to be cracking a joke, right? I mean, so Siri can tell you a joke if you have that on your phone, or Alexa, but it would not know why is it funny, when to say it, and all of those things, right? So that human beings can. This is again your emotional intelligence. I feel that the best speakers are the ones who know the law, who are happy, who are pleasant, who are there to help you, who are there to also learn, who have done something or the other that's unique. And whether it is, try to bring in, for example, if your problem is criminal law, try to bring in constitution, try to bring in jurisprudence, say a good line from a excellent thinker and say how this connects. Spend time, by all means, writing your content well. I'm not saying, when I said don't write a script, I didn't mean that you should not have a plan. You should definitely have a plan. Barack Obama, who's one of the finest speakers ever, is is obsessed about his scripts, is obsessed about what he says. It's planned for days and days. Of course, he also slight differentiation. He happened to be the president of the United States, but he's very, very, and he's got the sensibility of a writer. He's very well prepared. He knows humor and so on. So your preparation should be that. And I think what would differentiate is your visualization. If I've thought about 20 different ways that the hearing may turn out, and you've thought only of 10 different ways the hearing may turn out, I'm going to win because I've thought more about it. I've anticipated more. I have foresight. And of course, nobody has a crystal ball, right? We are not astrologers here, but you can anticipate. And I think this is what differentiates good speakers from great speakers, or good advocates from great advocates, or good thinkers from great thinkers. Your ability to look at the past, your ability to look at the present, and using all of that, trying to come to a reasonable conclusion on what the future may be. And if you are able to do that to a great extent, then there are no surprises for you in the court. Then you're comfortable. यार ये तो मैंने सोचा था, ये तो मैंने बात किया था अपने फ्रेंड से, कल रात को ये मैं डिस्कस कर रहे थे. तो वो बड़ा कंफर्ट देगा आपको. तो वो बहुत जरूरी है करना. वो आप लिख के करें, लोगों से बात करके करें. कई बार आप अपने आप को भी सुनेंगे ना बोलते हुए, तो आपको अपने आप को भी आप पढ़ा रहे होते हैं उस प्रोसेस में. तो अपने आप को भी नए आइडियाज आते हैं अपने आप को सुन के, because then your ears are also involved. What you are saying is going directly in your head because you're listening to yourself. So keep doing all of this and have fun while doing it. I think that's important, because if you're not having fun ना, तो वो दिखेगा. फिर वो लगेगा कि forced है. फिर वो साफ लगता है कि ये इसके लिए करने के लिए कर रहे हैं. या
It's fun because it doesn't have any consequences. Even if we fail, no one is going to get harmed. So
yeah, but that doesn't mean you take it with any less seriousness. It's definitely your effort should be 1,000%. And you should in fact think that there's no pressure. Yeah, I mean, some people perform extraordinary under pressure, and I think some amount of pressure is always good. Today also, when I'm arguing a case, there's a part of me that's nervous, there's a part of me that's anxious, and that anxiety is what keeps me up the last night. That anxiety is what keeps me, on a cold morning, keeping a 5 o'clock alarm, right? Who wants to do that on a 31st December? But you do it because I can't stand embarrassment in the court. I need to know everything there is to know about the subject. There should be no surprises. And so some amount of optimum paranoia is good, but it should not paralyze you. It should not debilitate you. It should not make you so nervous that you are tongue tied. And it is okay if you're tongue tied too. Take it in your stride. But if you practice enough, let me tell you, you won't be tongue tied. And let me tell you, you know more than the judges on that moot court, because you've spent a lot of days with the problem. They haven't. I mean, they may have experience on their side, but you are closer to the problem than they are.
Thank you. Thank you very much.
So we have one question in the chat box, and this will be the last one.
Right.
So the question says, how to detach yourself as a lawyer from the emotion you have for some topic or for some facts. Is it good to have emotion as a lawyer and get attached to the case?
So just give me a second. Yeah, great question. I would say it's a very clinical sort of a detachment. The question is it good to have emotions as a lawyer? Of course, I mean, it's good to have emotions as a lawyer. We are not machines at the end of the day. We are dealing with human beings. We are dealing with lives. If you are not responsive, if you are not sensitive, if you're not compassionate, if you don't have empathy, you'll never be a great lawyer. Let me be very, very clear. Because you cannot see, you may sometimes feign that you care, but the best people are the people who actually care. But then the question is, if you care too much, if you feel too much about the case, you won't start crying in front of the court, right? You wouldn't lose your voice. You wouldn't become angry. You would not be provoked easily. That shouldn't happen. So that's called clinical detachment. Your hands shouldn't shake when you are, performing an operation. That's the reason surgeons don't perform on their own family, right? They get another surgeon to perform. So that is the reason we don't fight our own cases. We don't fight our own legal battles. It's always good to get a lawyer to do it for you, because that person brings his independence, brings objectivity, brings in some sort of a detachment. But it's a very careful balance, because कुछ लोग इतने detach हो जाते हैं कि वो फिर एक task हो जाता है, वो एक फाइल बन जाता है, वो human life नहीं रहता है, फिर उसको लगता है केस है, ठीक है. That's never great advocacy. Right blend, and like in all things in life, the beauty lies, or the right answer lies somewhere in the middle. Right amount of sensitivity, at the same time take a step back. Don't think your client is right on everything, and don't even claim that. If your client's wrong on certain things, please concede. Tell the client and tell the judge that you understand that your case is bad on certain counts and so on. By all means, have that independence. And when you just keep these two words in mind, clinical detachment, but at the same time retaining sensitivity and compassion. So yeah, that's my very meandering answer to a simple question.
Thank you so much, sir,
Yeah,
for taking out your precious time as always and spending it with the law students of Hilsar, who are always passionate to hear from you. Now
thank you very much. Thanks for having me. Yeah.
Thank you so much, sir. Now I request Ms. Nazish Fatima, Assistant Professor of Law, Hilsar, to deliver the vote of thanks.
A very good evening to one and all. It gives me immense pleasure to deliver the vote of thanks for this event to all present here. On behalf of the Moot Court Committee, Hilsar School of Law, Jamia Hamdard, I would like to express our heartfelt gratitude to Professor Dr. Iqbal Hussain, Dean, Faculty of Law, Jamia Millia Islamia, for gracing today's event. Thank you, sir, for enlightening us with your kind words. A special thanks to Advocate Bharat Chugh for taking out his precious time and sharing his knowledge and expertise. We have been really inspired by you.
I would like to thank Janab Hamad Ahmed Saab, Honorable Chancellor Jamia Hamdard, for his support and guidance. A big thank you to Professor Dr. Muhammad Afshar Alam Sir, Honorable Vice Chancellor Jamia Hamdard, and Professor Dr. Selina Bashir, Dean, School of Law, Jamia Hamdard, for their commitment and consistent support to organize events such as these. I must mention my deep sense of appreciation for our faculty convener, Burhan Majid Sir. Without him, this event would not have been possible at all. Additionally, I would also like to thank the student coordinators, Tushar Batra and Sakshi Singh, for their continuous hard work in organizing this event. Last but not the least, a special thanks to all the participants for their active participation. I once again thank you all present here.
Okay, thank you everyone.